Hello, my name is Jim Cryer and welcome to this discussion of intellectual property and protecting the rights of creative authors. Today I'll be talking about a number of different things pertaining to the concept of intellectual property. The first thing we'll be doing is looking at some international definitions and how the world views intellectual property. We'll be talking about copyrights and patent laws and how these things protect the rights and authorship of these unique creative properties. We'll be looking at the rights that are actually protected by patent laws and copyright laws and how those are affected to the actual author. We'll also be talking about the limitations on those rights so that items of creative authorship can be used in the classroom for educational purposes. The term intellectual property actually refers broadly to the creations of the human mind. Intellectual property rights protect the interests of creators by giving them property rights over their own creations. Intellectual property is actually divided into two categories: industrial property and copyright. Industrial property includes inventions, patents, trademarks, industrial designs, and geographic indications of source. Copyright, on the other hand, includes literary and artistic works such as novels, poems, and plays, films, musical works, artistic works such as drawings, paintings, photographs, and sculptures, and even includes architectural designs. Rights related to copyright include those of performing artists in their performances, producers of music in their recordings, and those of broadcasters in their radio and television programs. Now, while other types of intellectual property exist, it's helpful to explore the distinction between industrial property and copyright in terms of the basic difference between inventions and literary and artistic works. Industrial property and inventions can be defined in a non-legal sense as new solutions to technical problems. These new solutions are ideas. Copyright law, on the other hand, protects only the form of expression of ideas, not the ideas themselves. The creativity protected by copyright law is creativity in the choice and arrangement of words, musical notes, colors, and even shapes. For the purpose of copyright protection, the term literary and artistic works is understood to include every original work of authorship, irrespective of its literary or artistic merit. The ideas in the work do not need to be original, but the form of expression must be an original creation of the author. The Berne Convention for the Protection of Literary and Artistic Works actually listed some examples of just such specific types of items. They included books, pamphlets, and other writings, lectures, addresses, and even sermons, musical compositions, motion pictures, works and drawings, paintings, architecture and sculpture, and even photographs. The most important feature of any kind of property is that the owner may use it exclusively, that is, as he or she wishes, and that nobody else can lawfully use it without his or her authorization. There are actually two types of rights under copyright. There are economic rights, which allow the rights owner to derive financial reward from the use of his or her works by other people. And there are moral rights that allow the author to take certain actions to preserve the personal link between themselves and the work. Now, most copyright laws state that the author or rights owner has the right to authorize or prevent certain acts in relation to their work. The rights owner of a work can actually prohibit or authorize a number of different activities. The first one is reproduction of their work in various forms, distribution of copies, public performance, broadcasting or other communications to the public, translation of their work into other languages, and even adaptation, such as a novel being made into a screenplay. Now, there are limitations on the rights allowed to items' authors. There are basically two types of limitations in copyright: free use and non-voluntary licenses. Now, free use carries no obligation to compensate the rights owner for the use of his or her work without authorization, while non-voluntary licenses, which we'll talk about in a moment, actually do require compensation to be paid to the rights owner for non-authorized exploitation. Now, some examples of free use include quoting from a protected work. That would provide that the source of the quotation and the name of the author are actually mentioned, and that the extent of the quotation is compatible with fair practice. Use of works by way of illustration for teaching purposes, and even news reporting of the items. I mentioned non-voluntary licenses, and a good example of this is the use of music even in church services. They are allowed to sing a particular song, but it cannot be broadcast over the internet, it can't be recorded, and it cannot be sold. And in fact, if one were to do so, although prior authorization would not necessarily be required, they would need to compensate the original rights owner for that particular non-authorized or even authorized use of that work. In order to set some guidelines and provide some assistance for teachers in the area of multimedia content, in 1996, a U.S. Congressional subcommittee actually published a report called the Fair Use Guidelines for Educational Multimedia. And this particular guideline showed that teachers can generally expect that there's a certain limit to the types of works that they can use in the classroom without starting to infringe upon the rights of the original author. For instance, motion media, that's to say video. A teacher can use 3 minutes or up to 10% of the content, whichever is less, in a complete fair use way without having to consider reference or compensation to the original owner. In conclusion, there's a number of things to think about and remember when we're talking about intellectual property. Intellectual property rights protect the interests of the creator by giving them property rights over their own creation. Rather than limiting creativity, these intellectual property laws actually encourage artistic creativity because it protects the rights. Inventors, authors, musical composers, they know that their work will be protected and that it won't be just taken by others and used however they want. Thus, it actually encourages creativity, encourages people to create and to have ownership of their own things. It also protects the rights of those individual artistic and industrial creators. The global community has adopted numerous laws that are actually observed and protected geographically and across borders. Yet, there are still, as I mentioned, fair use exceptions that allow limited use in the classroom without prior authorization for the purposes of educating the student, educating the public via news, and making bits of information available in terms of reference through the use of citations.